Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. My name is Dan Balkaran, as you can see on the screen, and I'm an employment lawyer at Samfiru, Tumarkin, LLP, which, as always, is Canada's leading employee-side employment law firm. Housekeeping notes: if you have any questions or need to contact us at all, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. This is my first session since before the holiday break. I hope everyone had a wonderful holidays and a very happy new year. Please get your questions in as soon as possible. I would like to get to all of them before the end of the broadcast. Thanks very much. And I've got a couple questions coming in, so I'm just going to get to those now. Okay. Question from someone I'm not going to use to identify. So, can an employer force you to go off on disability leave if they're unable to provide workplace accommodations? That's a really interesting question. No. So, you have to look at it this way. What disability is the means by which you get paid during your medical leave. Okay, but it's the medical leave. You're medically unable to work, properly papered by some sort of medical note, usually to confirm that you in fact do have the you're medically unable to work. That's what prevents you from working. But you want income while you're on some form of income while you're on leave, and you can get that either from medical EI or which is for a shorter duration, and for some employers who offer benefits to you through in third-party insurance companies, you can get paid through the insurance company on what's called disability, short or long-term disability, and it'll be a percentage of your wage that you're paid, provided that you meet the appropriate tests and medical requirements of the insurance company. So what this person is asking here is, I have X injury. I have a back injury, let's say, okay? And I can only lift 65% of what I used to be able to lift before the injury. And this person's doctor has said, it's got this back injury, can't lift, at least on a, for the immediate future, we don't know how long, has the back injury, can't lift more than 65% of what he was lifting before. So he'll need to be accommodated. And, the workplace is a construction yard. Construction yard says, well, we can't accommodate that. We don't have a job for you. And because it's core central to your job that you lift over 60 pounds at a given time. So the employer has said, well, we don't have a job for you. You can go on disability so you can keep having income coming in. So they're suggesting that as an alternative. What they're really saying to you here is, we don't have a job for you. You can't come back to work. And so you can treat that as a termination of your employment because they're required to provide you with accommodation. But the accommodation has to be, it has to be reasonable. Okay. It can't, like in the scenario that like the duty, the core job duties you have can't be fundamentally impacted by the accommodation you require. So if your job requires, if the job requires you to lift 65 pounds and you can only lift 20, and you claim you've been terminated because they can't bring you back to work, well, probably what's happened here is that your employment has been frustrated, i.e. extinguished by no fault of anyone's. It's just you medically can't do the job anymore. And a core tenet of it is that you're able to lift 65 pounds. And so these cases are incredibly complicated if you did elect to go the triggering of a termination route, because they're going to argue effectively that you no longer can do the job, and therefore you have no rights, no severance, nothing. Everything is extinguished. And you're going to say, no, I can lift 45 pounds. Most of the time my job is 45 pounds. 3 times a day I have to lift 65 pounds, and I can get a buddy to help me. That's what these cases turn on. They're complicated. Sometimes they involve medical expert reports. Nobody should do, if they're going to trigger a termination on a basis of failure to accommodate a disability, no one should take any steps, including triggering a termination, without talking to a lawyer first. They're just too complicated. You want to know what your realistic rights are. If in fact the employer should have accommodated you and didn't, or it's reasonable to make the accommodations you're asking for, particularly if it's on a temporary basis. You might have a termination, and you might have a good case to severance, which can be as much as 24 months, depending upon what your contract says and your age, length of service, and position. So, but it's incredibly complicated. You have to talk to a lawyer first. I strongly recommend to everyone that you take no action in such situations without talking to a lawyer. So I'll call you B. You need to talk to an employment lawyer. You can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. And B, just to wrap up your question here, I don't know how long your injury is going to last for. Is it permanent? Is it not? But if it's not permanent, what your employer is really doing is offering you a way to get income to perhaps live for another day. So maybe you're unable to lift 65 pounds for 12 months as your back heals. So you could get income from disability and your job's still there, right? So it may be that it's actually a good solution. I don't have enough facts in terms of what you've put forward. So I certainly encourage you to talk to an employment lawyer. I'm not going to use this person's name either because it will identify them. So my employer gave my position to the temp who replaced me while I was on maternity leave. It happens an unfortunate amount. When I returned, I was told a new position was being made for me. Then 14 weeks later, there was not enough work for my position, and I was let go, but my replacement is still employed. I worked there for 8 years. Is there anything I can do about this? Yes, there's lots you can do about it. So you are going to have a severance claim and a human rights claim. Now, the severance claim, depending on what your employment contract says, could be limited to, as much as 8 weeks, or it could be, many months of severance, depending on, again, what your employment contract says and your age, length of service, and position. So that's one component of it, but they obviously fired you because they replaced you while you were on maternity leave. And so that's discrimination on the basis of sex under the whatever human rights legislation exists in your province, or if you're in the federal jurisdiction. And that is a big no-no. And so you're going to have a claim through your human rights regime to, in BC, we call it injury to dignity damages, but also potentially lost wages through that avenue, again, depending upon the tailoring of your jurisdiction. So short answer is, they can't do that. Your employer cannot, because of your maternity leave, end up firing you, and they really don't have a good defense in this situation. So you should talk to an employment lawyer right away, but certainly you have a claim there. You likely have multiple claims, and you should talk to an employment lawyer immediately, so the lawyer can assess the strength of your claims and then move your matter forward. So if you want to reach us, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But yes, I'm sorry to hear about that. No one should lose their job because of a maternity leave. I strongly encourage you to talk to an employment lawyer immediately, because it sounds like you have a good claim there. So, okay. It's another internet handle that will identify the questioner, so I'm not going to identify them. I'll just call this person Jedi. Okay. My employer is chewing me out verbally for pointing out health and safety issues, telling me it's not my place to say anything about them and that I should just do my job. Should I talk to the labor board? Okay, so it was a tough one. I don't know what industry you work in. Certain industries are less forgiving than others for safety complaints, we'll say. So you're going to have occupational health and safety legislation in whatever jurisdiction you're in, and that legislation will have some sort of administrative body that assists employees with safety issues, and so that you can bring your complaint to. So, for example, in BC, it's called WorkSafe BC, and so if someone is unhappy with the safety the safety regime in place, or we'll say the safety issues that you're talking about, unhappy with it in their workplace, they report it to the employer. Employer does nothing. The employee can then take their complaints to, in our case, WorkSafe BC, and WorkSafe BC will contact the employer. I believe that's right, and an investigation will be initiated. The WorkSafe BC will then issue, after a period of time, a ruling on whether or not there was a safety issue. The employer, during that period of time, cannot terminate the employee or have any sort of reprisal on the employee for making and that's enshrined in statute, safety complaint. And if they do, they have a right of action through what's called the prohibited action process, which can lead to a substantial amount of severance against their employer. However, I will say, yes, that avenue does exist through, and I imagine it's largely the same through all the occupational health and safety legislation regimes across the country. But I will say that if you make a safety complaint to a government body about your employer, you are not going to be your employer's favorite employee. And I expect that relationship will not have durability across time. So if you make such a complaint and they have to, fend off and deal with scrutiny from occupational health and safety body, I imagine the employer I just can't see your employment lasting more than 2 years there, unless it's something that the employer is prepared to accept with grace, but I have rarely seen that. So you have to balance it out. I mean, these might be serious safety violations. These might be things you just can't do. I talked to someone a few months ago, and this particular individual, there was something that he was being asked to do that was just so wildly unsafe that he just couldn't do it. He was just like, no, I'm not doing this. And there was a tension with the employer there over it. Now, that particular person was sort of uniquely qualified and well compensated and had leverage in negotiation, but these things are tough. You have to assess what the safety issues are and whether or not you're prepared to risk losing your position over making a complaint about them. So the best solution is usually an amicable one with your employer, where you point it out and you guys work through it and it gets resolved. But even there, I've seen it where people complain too much to their employers about safety issues. Then the employer, particularly in some areas, like construction, or they don't want to hear it, and you find yourself not employed there anymore. So it's a balance. It's tough. I don't know what to tell you other than workplace occupational health and safety legislation and administrative bodies exist wherever you are, and you can bring your complaint to them if that's the route you decide to go. But there are risks attached to that. Okay, at least yes, protected by the legislation, but realistically, over enough time, long enough time scale, there are risks attached to it. Okay, RB asks, what if you were laid off temporarily because of these trade issues with the U.S.? Would employers be allowed to not pay severance because of financial hardship? To the second one, no. Severance is a mandatory obligation. They're not relieved of doing so. The only analog that I can think of is during the pandemic, everyone was placed on a temporary layoff, and the temporary period was extended before the employers had to actually treat the employees as terminated and then deal with severance. What you're talking about is really just absent. So the government can intervene, right? And they did during the pandemic. They might here. If government intervenes, then the law will change, at least on a temporary basis. But if you're laid off temporarily, as of now, then you stay on layoff until the end of this is somewhat in debate, but the end of the statutory layoff period at which time your termination is triggered, and it's 13 straight weeks in BC, for example, and then you can pursue severance that way. It's in debate as to whether you can only pursue employment standards severance or common law big severance, small severance or big severance, and certainly I think that eventually that'll be resolved to the answer of both. But would employers be allowed to not pay severance? As it currently stands, no, absent government intervention. But I certainly hope that, I certainly hope that there isn't a large-scale impact on the economy and that no one loses their jobs over this, because it's certainly that would be a terrible outcome. Question from Summer. I'm a salaried employee. Our managers have always told us that as we are on salary, we are allowed to leave early without having our pay deducted if our work is done. We've been told verbally that we are not expected to make up these hours. Recently, our managers have sat us down and explained that those who leave early owe the company hours that they haven't worked, and that the company can start withholding pay from employees who owe hours to make up the time they did not work. Can they do that? You're a salaried employee, no. I mean, the short answer is probably no. But they're saying you got to work the hours you're scheduled to work. So what they're actually saying is the regime has changed. In the past, so before I was a lawyer, I used to run call centers for major technology corporations, and certainly the stock of and trade of some managers there was, I can't play around with, certain elements of compensation, but I can give hours and days off to try to balance out, who does what in what situations. And you'll find that particularly in the service sector, many managers do that. And that seems to be the regime that you had. And now, the senior management has learned of this and does not like it. And so now they've said, you got to work your hours. So you got to work your hours. That's what you're paid to do. And now you have to work your hours. I think a bigger problem is if you don't work your hours, you're probably going to get run afoul of the company and get written up and then eventually terminated for cause. And so, now that they've put you on notice, you've got to work your hours. Now, if you keep leaving early, I think you have a risk of discipline and termination. Can they dock you pay for that? They could try. You may have a constructive dismissal claim for that. You may not, depending on the severity of the docking. And it sounds fairly ugly. I would just not do that, and I would work my hours. So I don't know. That's the thing, right? Like, employers can do lots of things, but whether or not they get away with it depends on whether or not the law is on your side, and B, you're prepared to enforce that law, right? And many times you're not, particularly if you want to retain your job. So it sounds to me like this is really just a simple solution. They want you to work your full 8 hours in a day or whatever you're scheduled for. So you work the full 8 hours in a day, and then nobody's upset. So if I've misunderstood, just let me know, Summer, but I think I answered your question there. Next question. How many more do we have? A few. My employer is saying that most of the staff are considered contract employees, so we aren't owed the same thing as full-time staff. Is that true? Contract employees don't get overtime or vacation pay. So just to correct your terminology there, it's not that you're a contract employee, it's that you're considered a contractor. Okay? So in our employment legal system, employees get all the rights and benefits, or all the rights attendant to employees under the Employment Standards Act, and then deductions, under the various federal programs such as EI and CPP. So you can't be terminated as an employee without some form of severance, statutory minimums, and perhaps more than that, depending on what your employment contract says. There's another classification called contractor, which is not an employee, okay, and therefore does not get severance, overtime, et cetera, all the different components of ground floor entitlements under the Employment Standards Act, if you're provincially regulated. And then there's a third category called dependent contractor, which is sort of between those two. So in our modern economy, particularly with the gig economy, many employers are trying to engage for services more and more staff as contractors because it costs them less. And the contractors can take advantage of a more relaxed tax regime, or at least slightly smaller tax burden, where the money's not taxed at source, and then the employee deals with their tax obligations directly with the government. So just because an employer is doing that doesn't mean legally you're a contractor. And so this comes up a lot in employment law disputes where employer says, no, I paid this guy as a contractor for 10 years. I don't owe him any severance. And when you look at the particulars of the employer and of the arrangement between the employee, and the contractor and the employer, the contractor worked 40 hours a week, didn't work for anybody else, got the same paycheck every week, used the tools of the employer and wore the employer's uniform and was held out as an employee of the company, of the employer to all company customers. And so, a person will be held to be, correctly an employee, and therefore is entitled to severance. But you're not asking about that for this. So that's when those disputes are fought over, and there's a pile of money that we call severance that is in dispute between the parties. That's not what you're asking about. You're asking about whether or not, as a contractor, you can get overtime and vacation pay. So the short answer is, are you a contractor? You may be, you may not be. The core of the test is, are you working for yourself or are you working for the company, right? And there's all kinds of factors that go into it, but that's the core of the test, and the legal test. And so, it could be that you are, do you work for any other businesses? Do you have your own employees? Do you just have a set hours schedule, all that kind of stuff? And it could be that you are in fact an employee, but you're being paid as a contractor. In order to challenge that, though, there has to be a significant enough amount of money in dispute for you to make it worth your while. And usually overtime and vacation pay doesn't get you there. So I don't expect you to be able to resolve that other than amicably with the employer. So you could talk to them and say, well, I'm not actually a contractor. I'd like these things. You'd see what they say. But remember, if you come out of being a contractor and you're paid as an employee, then you're going to have to pay CPP and EI dues. And you're going to be taxed right away up front, and the tax amount will be higher. Your tax bracket will be higher. So theoretically, there's pros and cons, and can you get a lawyer involved to fight that out? Probably not. The money's probably not there. But could you be an employee, strictly speaking, by the letter of the law, such that you should get the entitlements of the Employment Standards Act? Yes, you could be. You could also make an Employment Standards Branch complaint and get a ruling from the Employment Standards Branch on that question. But like I said earlier in this broadcast, if you make an Employment Standards Branch complaint against your employer, particularly if the employer loses, while you won't be terminated in the short term, I can't see you having a long relationship or a long service at that employer, because they're going to be upset. So, I think as so many of these situations go, the best solution for you is to see if you can work it out with your company there. Okay, Gloria asks, how to clear my name for slander? My employer and coworker are calling me a thief, and I need to clear my name because it's becoming a big problem. Okay, I don't understand. If your employer is saying you stole something, they should fire you for just cause. But if they don't have any evidence and you didn't do it, I think that you could claim constructive dismissal for accusing you of being a thief. Probably. I don't see how the relationship of trust can continue after that point. Although, constructive dismissal, I think on a repudiation basis, depending on how serious, the allegation is, and it depends on the facts. But yeah, I think you could claim constructive dismissal. So if your employer says you stole something from me, and stands by that you didn't, and they don't have any evidence, yeah, I think you could probably force your way out with some severance. It would be messy, and it would be determined entirely based on the facts. That's not your question, though. Your question is how to clear my name. I don't know what that really means, other than how do you convince your employer that you didn't do the thing that your employer is convinced that you did. I have no idea how to do that. You depends on what the evidence is. I don't know, like, if they haven't, generally speaking. So, for example, big box store, this happens quite often, or a chain store. Some young employee, not always young, but quite often, will steal money out of the cash register. They'll get caught, and they will be led away in handcuffs, and they'll be charged generally. Those stores take it very, very seriously. If you actually stole, the employer should have fired you for just cause and probably called the police. And if that hasn't happened, then I don't really know what's going on there, but I can't see that relationship working. I mean, have you been there for 25 years and you got to sort it out? Maybe, but generally speaking, if somebody says that I stole from them, I'm going to go work somewhere else. And, particularly if there are no consequences attached because there's no evidence and they're not pressing charges or anything like that, you may want to just go somewhere else, because I just don't see how that relationship continues. So those are my thoughts. If we're almost done, but if you have any other additional questions, because that's a unique situation, please feel free to jump back on and ask. Hey, Jay, good to see you, Jay. What if anything can be done about employers pushing out long-time on-call employees and replacing them with cheaper labor? I don't understand your question, Jay. Employers have the ability to terminate without cause and hire as they see fit. That's just the law. So if you've got an employee who's making $50 an hour and you think that's too expensive, the employer thinks it's too expensive, you can fire that employee, pay him the appropriate severance as required by the law, and then replace him with somebody who's making $25 an hour. But you might get a ability difference between those two, and that balancing of those different inputs and concerns is what we call the economy, right? So nothing. Yeah, the short answer is nothing. That's just the economy writ large. Jedi's back. In the cleaning industry, I've pointed out problems with chemical issues, no labels, wrong labels, no PPE, no designated health and safety person, no eye washing station, etc. Those sound like serious issues. The cleaning industry, though, is always looking for people. So, is it a situation where maybe you just go work for somebody else now that you have this experience on your resume? Because lots of them take it very seriously, very, very seriously. I mean, the cleaning is very, it's a high risk activity, and so a lot of them realize that in order to keep people, you need to have particularly appropriate PPE, but everything that protects the employee's safety as much as possible. So, maybe you just want to go work for, an outfit that looks out for your safety a little more. However, you always have the ability to complain to occupational health and safety legislation body. Again, in BC, it's called Workplace BC. I don't know what it's called anywhere else. You have that ability. It's just how your employer view you after that. I don't know, and I don't know what your long-term viability with that employer will be, but certainly that option is open to you. So I'll leave it there. It looks like Gloria's not going to jump back in. So great questions. We got through everybody. It was good to see everybody back in the new year. Oh, Jay's back. I'll do this one last question, then we gotta step out. Jay was the one who asked about pushing out on-call employees and replacing them with cheaper labor. Example, calling in $20 labor instead of 30 to 40 that we've been working for years. I know possibly triggering severance, but could be an option, but anything else? So not call, like if they're on call and you call somebody else, I don't think that's anything. I don't, of course they're going to call in the cheaper labor. So no, I don't see any. This is non-union work. I don't see anything arising out of that. I think that's just the business's prerogative. So but if you're not on call and then you don't get a shift for a month, yeah, that's probably a constructive dismissal. But is there anything to force your employer to call you? No, there isn't, other than working it out with them amicably. Okay, we've gone long. Thank you, everybody. Have a wonderful and safe weekend. I will see you here in 2 weeks. You will see us all on Monday, February 3rd at 1:30 p.m. Eastern Time with Chris Justice. Come join us for that. It'll be a great show. Otherwise, have a great